by Professor Hoppe to speak here in this delicious temple of knowledge and liberty, of wisdom and delight. I didn't only feel very honored, but also felt a little bit uneasy because I considered various negative options not to be able to come to your expectations, but also I considered marginal things. For instance, I thought whether it would be appropriate to cover my head talking here. Because as you know, the Romans, when they went to the temples to worship the gods, they covered the head. And they did it with every god, and the meaning of this gesture was obvious. No? So you hide your weaknesses and you hide your sins from the gods. But there was one god, one temple, in which they did not cover their heads. And this was the temple of Kronos, the god of time. And Plutarch, in his fragments about Roman customs, explains why. Because he says, time brings to light everything. Sooner or later, the truth comes out. So it's completely useless to cover your head in the front of time. We need time to understand, and we know that developments occur in time and they show themselves, they reveal their real nature in time. My argument touches time because it's about crimes, historic crimes, and the way how these crimes were redressed or not redressed afterwards. I came in 1990, a few months after the Velvet Revolution in Prague, from Italy to Czechoslovakia to work as a foreign correspondent in several post-communist countries. When I came to Prague, I still shared the common belief that nationalization, expropriation, confiscation was a specific, more or less exclusive feature of communism. It is not. It is just one of three possibilities of governmental theft. The first one, the easiest one, is inflation. Almost without violence, it allows the state to steal money continuously and in relatively small amounts almost from everybody until withering confidence in the currency dies. The second method is taxation. This is a little bit more difficult and potentially dangerous for the government because it's under the direct threat of violence and it provides much money from a majority of people. So if you overdo it, you will have a rebellion and it's difficult to get away with this. And the third way is mass expropriation and confiscation. It takes all property from a minority which before has to be outlawed and completely deprived of domestic or foreign protection. It's possible only under exceptional circumstances, basically during a revolution which transforms a society in the gulag, or after a war. It is necessarily violent and it's very often linked to forced population transfers. And it's by no means an exclusive feature of communism. The whole history of the 20th century could be told as a history of confiscation and mass deportation. Let's start with the Balkan Wars in 1912, 1913. Between 1913 and 1923, about 3 million people fell victims of population transfers and confiscations in Europe alone. Approximately 900,000 Muslims from the Balkans, Greeks and Bulgarians during the Balkan Wars. About 160,000 Bulgarians and Greeks after the First War, after the Treaty of Neuilly. About 1.6 million Turks and Greeks after the Treaty of Lausanne. And there was an interesting case which is not so well known in Western Europe as well, and it regarded the Germans, mostly very much assimilated Germans, in the French province of Alsace. Under the presidency of Georges Clemenceau, about 150,000 Germans were selected by governmental commissions. They were called Commission de Triage, and had to leave Alsace if they were detected Germans. And in order to speed up this whole process, anybody who denounced his neighbor as German could apply to get his property. The list of this, what I mentioned, those 3 millions, is probably incomplete. It's a very conservative estimation. Population transfer is understood in the most strict sense of the definition. Not included in this 3 millions are people who left their country and their homestead after the formation of new national states. It was about 800,000 Germans who left Poland, about 425,000 Hungarians who left Slovakia, Romania, and Yugoslavia. That means that in the new Wilsonian democratic national order, about 4 to 5 million people lost their homestead and their property. This, let's say, democratic prelude to the forced population transfers of millions of people under the totalitarian regimes of Stalin and Hitler between 1938 and 1944 affected then probably more than 7 million people. It's obvious that in this figure, the 5 to 6 million victims of the Holocaust are not included. The far biggest population transfer in Europe occurred at the end and after Second World War until 1948, and it affected more than twice as many, 12 million Germans from Eastern Europe, 4 million among Finns, Poles, Ukrainians, Serbs, Croats, Slovenes, Hungarians, Slovaks, Italians. About 2 million died during those transfers, all things after the war. Communists contributed to these crimes, but they were by no means the only perpetrators. In the case of Czechoslovakia, they were even rather reluctant when the democratic President Edvard Beneš presented his plan to expel roughly 3 million Germans, a quarter of the population of his country, and to confiscate their property. The so-called Beneš decrees, or presidential decrees, initiated the ethnic cleansing and desocialization immediately after the war. The national and social revolution in Czechoslovakia was nearly accomplished when the communists ousted the democratic parties in February 1948. About 80% of the Czechoslovak economy had been nationalized in 1945 and 1946. Immediately after the war, Beneš ordered the nationalization of all banks, of all insurances, and of about 3,000 companies in all industrial branches. The expelled Germans left about 5.68 million acres of fields and forests behind. The major part of their confiscated property was first divided among Czech and Slovak settlers, then collectivized after the communist takeover. From the 50s until 1989, even groceries and flower shops in Czechoslovakia were run by government. Why is it so important to understand that nationalization and confiscation were not an exclusively communist feature? Because the restitution laws in the post-communist countries after the fall of communism set arbitrary and magical time limits. In the case of the Czech Republic and Slovakia, this magical threshold is 25th of February 1948, the day of the coup de Prague. If your property had been robbed by communists after this day, you get it probably back. It's not sure, but you have good chances. If it was robbed by Democrats the day before, you have no chance at all. Instead of giving it back to its legitimate owners, most of this property was not restituted, it was privatized. I want to quote, whenever I talk about restitution, I quote Murray Rothbard from The Ethics of Liberty. I like this very much, how he put it. Let us say, he writes, Ruritania is ruled by a king who has grievously invaded the rights of persons and the legitimate property of individuals and has regulated and finally seized their property. A libertarian movement develops in Ruritania and comes to persuade the bulk of the populace that this criminal system should be replaced by a truly libertarian society, where the rights of each man to his person and his found and created property are fully respected. The king, seeing the revolt to be eminently successful, now employs a cunning stratagem. He proclaims his government to be dissolved, but just before doing so, he arbitrarily parcels out the entire kingdom to the ownership of himself and his relatives. He then goes to the libertarian rebels and says, all right, I have granted your wish and have dissolved my rule. There is now no more violent intervention in private property. However, myself and my relatives now own Ruritania. And if you disturb us in this ownership in any way, you should be infringing upon the sanctity of the very fundamental principle that you profess, the inviolability of private ownership. Rothbard wrote this in 1982. A few years later, the communist kings in Eastern Europe dissolved their governments and gave up their political monopoly. But at the same time, they declared themselves, their relatives and their cronies, private owners of the former nationalized property. Rothbard's answer to these imaginary kings was the following. We are sorry, but we only recognize private property claims that are just, that emanate from an individual's fundamental natural right to own himself and the property which he has either transformed by his energy or which has been voluntarily given to him by such transforms. The only way to redress the injustice committed against private property would have been the restitution of stolen property to the legitimate owners or their heirs, a real and fair restitution without restrictions, regardless of nationality, ethnicity, language, religion, or whatsoever. Instead, the post-communist states excluded the broad majority of owners and their heirs from restitution and divided the property among a new class of nouveaux riches, mostly from the rank and file of the former nomenclatura. The European Union, in the process of integration of those countries, excluded the monitoring of the legislation on property and restitution from the political criteria. There was and is still complicity in the behavior of the European institutions. It is obvious that all this happened against the rule of law. As John Locke put it, government can never have a power to take to themselves the whole or any part of the subject's property without their own consent. Confiscation, by the way, is also prohibited by international law. In 1938, the US Secretary of State Cordell Hull demanded the prompt compensation for lands seized from US farmers and ranchers in Mexico. Hull underlined, I quote, that under every rule of law and equity, no government is entitled to expropriate private property for whatever purpose without provisions for prompt, adequate, and effective payment thereof. This is called the Hull formula, and it became since then part of many bilateral and multilateral treaties and it's nearly always respected when the United States and their citizens are in the game. In international law, the taking of someone else's property without compensation is simply theft. When the taking of the property is considered as an unlawful expropriation, then compensation should also cover the lost future profits in addition to the loss actually suffered. Nothing of this happened in the post-communist countries of Eastern Europe. And I want to say all this was also covered up by the American and the British government in the Agreement of Potsdam. So the very same people who stated the principles, international law and caudal hull did not respect it after 1945. 16 years ago, there was a rare, bright moment in the history of the Assembly of the Council of Europe. It adopted resolution number 1096, in which it warned against the dangers of a biased desocialization process that could lead to an oligarchical power structure, to state capture, increasing corruption, and organized crime. So you can read in this resolution, at worst, the result could be the velvet restoration of a totalitarian regime. Regarding restitution, the Council of Europe therefore advised, I quote, that property, including that of the churches, which was illegally or unjustly seized by the state, nationalized, confiscated, or otherwise expropriated during the reign of communist totalitarian systems, in principle be restituted to its original owners in integrum, if this is possible without violating the rights of current owners who acquired the property in good faith, or the rights of tenants who rented the property in good faith. In cases where this is not possible, just material compensation should be awarded. The denial and the restriction of restitution causes many negative consequences in the post-communist countries. First of all, it breaks the rule of law and undermines the legal order. The acquisition of robbed and stolen assets from the government in the course of privatization is not a legitimate transaction. It is fencing for a low cash price. Theft and fencing were already punished in the same way in Roman law. As property is not given back to the legitimate owners or their heirs, it ends in most cases in the hands of the old boys networks, former communists who easily compensate their loss of former political power with state capture and economic dominance. This leads to still greater distortions of competition and still more graft and corruption. Communists are still in power everywhere in Eastern Europe. Sometimes they call themselves socialists or social democrats, sometimes liberals or conservatives. Only the old communist relationship between state and corporations has been inverted. Before, it was the party and the state which organized the economy. Now, the network of oligarchs control the state, the government, the judiciary, and the political parties. This is, together with big government, the corrupting effect of mass democracy and the increasing burden of the welfare state, the most serious limitation of liberty in post-communist societies. Post-communist oligarchies represent a collective security risk as well, because they can be used, and they are used, by Russia, which tries to regain the influence it once had in this part of Europe. But let us return to the Czech experience. The lack of redress for countless illegal property confiscations that took place in the wake of the Second World War has been documented by the United Nations Human Rights Committee, so far with scant response from Prague. Big or small landowners, businessmen, professionals, members of the nobility or the Jewish community, all of them Czech citizens, are still denied their ownership rights. There was the case of Mrs. Eliska Fabriova, born in 1916. Her father was murdered by the Nazis in the concentration camp of Auschwitz. His property was Aryanized, as the Nazis called it. Mrs. Fabriova's restitution case has been denied by Czech courts. One of the arguments that her father was not only a Jew, but a German as well, and a traitor because, I quote, he had lived in a German way. There are only very few examples of restitution in favor of the aristocracy, which opposed Nazism during the war. A former Czechoslovak socialist minister of culture, Pavel Rychetsky, explained this once in the following way. I quote him, "The current aristocracy in this country is basically an occupying force. They all arrived after the Battle of the White Mountain." Well, the Battle of the White Mountain occurred in November 1620 during the 30 Years' War. The Catholics defeated the Protestants, and aristocrats from Catholic countries settled in Bohemia. Accordingly, the descendants of the Norman conquerors should be regarded as an occupying force in England too. The late Prince Kinsky, born in 1936, was a child as he inherited the entailed, fideikommis is the exact legal title for it, as he inherited the entailed fortune of his family. His father, who died in 1938, before the arrival of the Germans and the Nazis, had only been the trustee, the administrator and limited beneficiary of the entail, but not its owner. His mother emigrated in 1940 with her children to Argentina. Among her papers after her death, Prince Kinsky found his Czechoslovak children's passport, based on which his Czech citizenship was confirmed and the corresponding certificate issued. The first 5 of 157 claims were still successful. The Czech civil courts confirmed in 2003 that the state had assumed ownership without due legal ground. The then Socialist Minister of Culture, already mentioned, sounded the alarm. Politicians from all political parties got together for counsel about what to do to avoid the misuse of what they called a few former discrepancies. The government created a 30-man special union called Majetek, that means property, to block all property claims. This specialized police unit, focusing on aristocratic restitution investigations, asked the intelligence service to collect evidence in Austrian and German archives against Prince Kinsky. Czech police wiretapped not only the prince, but also his lawyer. This wiretapping was approved by a Czech court. The government presented even a falsified confiscation notification in the court. It came out that the District National Committee, which allegedly signed this notification in 1946, did not even exist in that year because the district was only created in 1949. In the meantime, the parliament passed the so-called Kinsky Law, which enables the state to interfere in ongoing court proceedings with restitution plaintiffs who dare to request property from towns. Now the towns obtain from public funds qualified legal aid, which the adverse part doesn't have the right to, an evident preference of public entities at the expense of private plaintiffs. In order not to give back the stolen property, the state doesn't hesitate to manipulate and undermine its own legal order. The government interferes in court proceedings, it falsifies documents, it controls and observes plaintiffs and lawyers with methods which are in open contradiction with the rule of law. And all this does not bother the European institutions, which cover up these crimes with a veil of silence. The Czech Republic, whose president is a long-time member of the Montpellier Society, is no exception. There are thousands of similar cases in other post-communist countries as well. Let's have a look at tiny Slovenia, a former Yugoslav republic under Tito where communism was no less communist than Soviet communism or any other communism. Tito's socialism is still considered as being benign and moderate. Also, the reign of terror in Yugoslavia, relative to its population, hardly differed from Stalin's Great Terror. According to various assessments, between 200,000 and 300,000 Yugoslavs were murdered in 1945, 1946. Between 45 and 50, at least 1 million people were caught up in the wheels of the communist judiciary and the secret police, every 10th inhabitant of Yugoslavia. The West rewarded Tito's break with Stalin at the beginning of the Cold War by overlooking his crimes. Eleanor Roosevelt, in her regular newspaper column, praised, I quote, the dictatorship of the proletariat interwoven with humanism, and called Titoism as Yugoslavia's last hope. Tito was successful, she explained to her democratic leadership, because he told the people the truth from the beginning. By the way, it's quite interesting that the attractiveness of totalitarian regimes was always particularly strong in the most bloody periods of totalitarian history. During the Stalinist purges in the 30s, there were a lot of Western intellectuals which were affected by this idea that Stalinism is this communism is the future of mankind. This was the case regarding Yugoslavia in the 40s, and it was also the case during the Cultural Revolution in China. So when most blood flows, the applause from the Western intellectuals is growing. In 1947, Ljubo Schwarz, now 92 years old, was sentenced to death at a show trial in Ljubljana because of his well-known anti-communist positions and his contacts with British diplomats. The secret police arrested him on the eve of Tito's birthday on his way home. In prison, he met Colonel Mitja Ribicic, the chief of Section 2 of the Communist Secret Service, OSNA, responsible for persecution of the internal enemy. Ribicic directed summary executions of actual and potential enemies of the regime. He later became Yugoslav Prime Minister and President of the Central Committee of the League of Yugoslav Communists. Ribicic and his men interrogated Schwarz into the early hours of the morning. For 4 weeks, he was dragged from his cell each night for interrogation and was not allowed to sleep during the day. The Secret Service officer and his victim are approximately the same age. Ribicic was born in Trieste in 1919, Schwarz in Krain in 1920. Both enrolled in the law faculty at the University of Ljubljana in 1938. When Germany invaded Yugoslavia in April 1941, Schwarz joined the left-wing nationalist resistance group Stara Pravda, meaning ancient rights. The communists discovered their patriotism only 2 months later, namely when Hitler's attack on the Soviet Union rendered the Hitler-Stalin Pact obsolete. Ribicic, a political commissar with the rank of a colonel, supervised the party reliability of the partisan detachments in German-occupied northern Slovenia. As Schwarz says, his most important task was ensuring that no non-communists would join the armed resistance. The commissars subjected the volunteers to a strenuous interrogation, including torture. Forestry workers found the corpses of partisans clubbed to death by the commissars. The so-called protective order of the Slovene People's Liberation Front of September 41 provided for the liquidation of those resistant fighters who did not submit to the communist-controlled Liberation Front. Contacts with foreigners, which Schwarz maintained as translator for the Yugoslav government, decided his fate in the show trials of 1947. Of 14 defendants, 3 were sentenced to death. Lubos Sirt's father, Franjo, who had no connection with the anti-communist opposition, was also sentenced to 10 years imprisonment with hard labor because his son was an enemy of the people and he himself a class enemy. Franjo Sirtz was a successful entrepreneur until the Nazis confiscated his property, dismantled his textile factory, and destroyed the buildings. What was left by the Nazis was confiscated by the communists. Franjo Sirtz died after 4 years in prison. Lubos Sirtz remained in prison for 7.5 years. In 1945, he succeeded in escaping over the mountains to Italy. He taught economics in Dhaka, in Dundee, and in Glasgow, and founded the Center of Research into Communist Economies in London. He has written several books on the failure of central planning and the biography called Between Hitler and Tito, which is amongst the best and most vivid descriptions of life in Yugoslavia in those times. Sirtz has tried to recover his property for over 20 years. The show trial sentence was rescinded in 1991. He immediately applied for restitution and compensation for unjust imprisonment. He did recover a few scattered pieces of his family's property, consisting of a house in Krain, except the business premises on the ground floor, part of the garden, and 600 out of 15,000 square meters of land belonging to his father's textile factory. In 1990, the Slovene parliament decided to return all confiscated properties, but restitution was dragged out and came to a complete halt. Sirtz had to appeal adverse decisions 3 times. Eventually, Slovenia was fined with a mere 18,000 euros by the European Court of Human Rights for dilatory handling of the claim, where the value of property involved amounts to almost 10 million euro. In 1998, the Slovenian leftist parties that regained power after a brief interlude retroactively modified the property restitution law of 91 to the detriment of the claimants. The rationale given was that fiscal exigencies of the social state were more important than the right to property. In rejecting the complaint made by Sirtz of discrimination as a result of the new law, the Constitutional Court of Slovenia argued that public interest justified a retrospective application of the law. Over 40% of property in Slovenia is still owned by the government. All 9 judges in the Slovenian Constitutional Court were still appointed by the former president Milan Kučan, who had also been the leader of the Communist Party of Slovenia. One of the 9, 8 were non-communists, including of the 9, 8 were non-communists, was also Cyril Ljubicic, the son of the communist butcher Mitja Ljubicic. Cyril was his father's partisan name. Sirtz's case was supposed to be a test case, but the European Court of Human Rights took 8 years to reach a judgment. In a left-leaning newspaper called Delo in Ljubljana, Boštjan Šupančić, the Slovene judge in Strasbourg, criticized, I quote, the gap between Western and Eastern thinking by which the European Court of Human Rights is characterized and where bourgeois mentality still prevails. And he ranted against yuppie legislation. Instead of feeling themselves bound by, as he called it, legal formalism, the judges should, according to Šupančić, exercise their legal power. Lubos Sirtz reports that he had drawn the attention of Lucius Wildhaber until 2007, the president of the European Court of Human Rights, to the peculiar understanding of law by the Slovene judge. Yet Wildhaber could not detect in the Slovene judge's view any infringement of the Unité de Doctrine at the Strasbourg court. Sirtz accuses the Slovene Constitutional Court and the section of the European Court of Human Rights, chaired by Šupančić, of bias. What is involved, says Schwarz, is the disregard of his right to a fair and public hearing by an impartial and independent court, and therefore of the disregard of his human rights, particularly of his right to own his property. In the meantime, Schwarz has no more legal options to get his property back. For utilitarians, restitutions is simply a nuisance. It is probably much easier to make a plan for a swift IMF-compatible transition. 10 years ago, Tyler Cowen wrote a paper which is quite often quoted among transition engineers in post-communist countries. Cowen argued sarcastically against intergenerational restitution. I quote, "The Hoppe charge that their lands were stolen from them by the Navajo. If the United States government returns the land to the Navajo, should it also return some property to the Hoppe?" The post-communist and transition economists, should we remedy only the injustice of the communist era, or should we go much further back and try to rectify previous injustices as well? Should it matter that the nobles virtually enslaved the Russian peasantry? Should it matter that Genghis Khan sacked Baghdad in 1258? Now, it is obvious that restitution is only feasible where property rights are evident and verifiable. I doubt whether this is the case with the Hoppe, the Navajos, the Russian peasantry, or the victims of Genghis Khan. Cheap sarcasm is not very helpful. It is true, Kronos, the god of time, devoured some of his children, and Kairos, the god of the right moment, is unpredictable. We do not know whether those crimes will ever be properly redressed. Probably not. But at least this must not blur our moral discernment. Thank you for your attention.